Today on Bench Briefs, we're looking at a landmark case that explores the delicate balance between professional regulation and constitutional rights. On this episode, we dive into Black v. Law Society of Alberta, a 1989 Supreme Court of Canada decision that questions how far a law society can go in regulating lawyers without stepping on their freedoms of expression and association. So, what's this case all about? At its core, Black v. Law Society of Alberta involves a lawyer named Black who was a member of the Law Society of Alberta. The Law Society, which regulates the legal profession in Alberta, had certain rules and provisions under the Alberta Legal Profession Act that governed what lawyers could and couldn't do. Black challenged these rules, arguing that they infringed on his rights guaranteed by the Canadian Charter of Rights and Freedoms, specifically his freedom of expression and freedom of association. To put it simply, Black felt that the Law Society's rules were too restrictive. He believed these rules limited how he could express himself and who he could associate with professionally. Since the Charter protects these freedoms, Black took the matter to court, claiming that the Law Society's authority went too far and violated his constitutional rights. Now let's break down the key facts. Black was a practicing lawyer, fully subject to the regulations of the Law Society of Alberta. These regulations are designed to maintain professional standards, ensure competence, and uphold the integrity of the legal profession. However, Black took issue with certain provisions that he said limited his ability to express his views and associate with certain groups or individuals. The dispute raised a fundamental question. Can a regulatory body like the Law Society impose rules that restrict constitutional freedoms? And if so, under what circumstances? That brings us to the legal issues the Supreme Court had to consider. The main questions were, first, do the provisions of the Alberta Legal Profession Act and the Law Society's rules infringe on Black's charter rights to freedom of expression and freedom of association? And second, if those rights were infringed, could the restrictions be justified as reasonable limits under Section 1 of the Charter? Section 1 allows certain rights to be limited if those limits can be shown to be reasonable and demonstrably justified in a free and democratic society. Another important aspect was determining the scope of the Law Society's regulatory powers. How far can a law society go in controlling the conduct of lawyers without violating constitutional guarantees? This case forced the court to carefully weigh the need for professional regulation against the fundamental freedoms that every Canadian enjoys. Ultimately, the Supreme Court's decision in Black v. Law Society of Alberta helped clarify the relationship between professional regulation and constitutional rights. The court recognized that while law societies have an important role in regulating the profession to protect the public and maintain standards, they must do so in a way that respects the freedoms guaranteed by the Charter. Why does this case matter in the bigger picture? Well, Black v. Law Society of Alberta set an important precedent for how courts approach conflicts between regulatory authority and constitutional rights. It affirmed that professional bodies are not above the Charter and that any limitations on rights, such as freedom of expression and association, must be carefully justified. This case reminds us that even in professions with strict rules, individual rights remain a central concern. For lawyers, regulators, and Canadians alike, Black underscores the ongoing tension between maintaining professional discipline and safeguarding constitutional freedoms. It's a balancing act that continues to shape legal standards and the way we think about rights in the context of professional life. Thanks for listening to this episode of Bench Briefs. Be sure to join us next time as we unpack another fascinating legal story from Canada's courts. Until then, take care.